So, when I said that there was probably blood in the water based on the funny business that was going on with the withdrawal and the things that were going on with the deposition, I didn't exactly anticipate this. Let's let's get into it.
Hello, and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it.
Let's get into it, guys. Holy cannolis. This is a wild development. I usually, when it comes to the titles and thumbnails and stuff, I don't want to be too clickbaity on things. So, if something doesn't feel like it's really a bombshell, I don't necessarily want to call it a bombshell. So when I put that in the title the other day, I was like, yeah, like this seems like there's something here. Like there's some information here that somebody is really, really guarding and they don't want to give over to the other side. And, like I said, if you watched my video the other day, I you saw me say it, right? Where I said that this is usually because they have information that is really damaging to their case, right? I didn't anticipate that the lawyer might be lying about what's going on with their client. Client, right? Okay. Hey guys, how are you doing? How's it going? Good morning, good afternoon, good evening from wherever you are. I hope you have had a wonderful week so far. Happy Friday. Let's say hello to some folks here in the chat. Jennifer Kaminsky. Hi from the dentist chair. Oh, I'm so sorry. I went to the dentist recently for the first time in an embarrassingly long time. It's so embarrassing how long it had been since I had gone to the dentist that I'm never go no one can ask. I'm not ever going to tell people because it's that embarrassing how long it had been. So, so kudos to you for going, taking care of your dental health. I recently went, so it was one of those things that was like I was really proud of myself because I was kind of terrified of it at that point. Um, anyway, hi Ginger Haynes from Alabama. We've got Raina from Stockholm. We've got Annette Matz from Melbourne. Welcome, welcome. Secret McSquirrel says, pretty sure you predicted this yesterday. Something smelled funny, right? Michael Fisher from Omaha. We have Micah Murch also from Stockholm. Calamity Jane from the UK. Thank you so much. This is so kind of you to say. Mew Mew 0203. Hi from Tokyo. Awesome. Libby K from Canada. Marie Ground from France. We've got some folks from all over the place. We've got Texas. We've got Estonia. We've got Livonia, Michigan. We've got DC. This is great. I love it. I always love seeing where folks are coming in from. So, okay. I mean, where do we begin? Okay. So, in case there's anybody that's not really familiar with what's going on here, what I'm talking about. So, I published a video a couple days ago, day before yesterday. I don't know, depending on where you are in the world, what day or time it is. Just the other day on the Esme Bianco case and the Ashley Morgan Smithline case, two different cases that are against Marilyn Manson. I've been focusing primarily on this channel on the Marilyn Manson case that he has, where he's the plaintiff and he has filed against Evan Rachel Wood and Ilma Gore. Before that video, I hadn't even really talked pretty much at all about Ashley Morgan Smithline, Esme Bianco, Ashley Walters or the Jane Doe case, all of whom had filed cases against Marilyn Manson, Brian Warner, professionally known as Marilyn Manson. So the so and to this day, I still haven't really looked closely at the complaints. So I don't know. I mean, I know generally speaking that they've alleged similar claims to what Evan Rachel Wood has publicly accused Marilyn Manson of. So, but beyond that, the substance of their claims, the specifics, the specific facts here and there, I haven't really analyzed those too deeply. So I don't have anything close to a conclusion as to the merits of any of those cases. The reason why this became so interesting was the sudden departure of Jay Ellwanger, the attorney for two of these plaintiffs, two of the four, Esme Bianco and Ashley Morgan Smithline, that he filed saying that he needed to withdraw from the case because he had been representing Ashley Morgan Smithline. Marilyn Manson's attorneys were trying to get her for a deposition. He had provided a reason for why she couldn't go to the deposition that was scheduled on August 17th. This is a deposition that is important for several cases, probably maybe all of the cases, but for her case individually already, she's a plaintiff in one of these cases, but she had actually been noticed or she had been served a subpoena in the Bianco case. So even though Ellwanger was representing her and Esme Bianco, and they both are plaintiffs, they have similar claims, and they're both against the same defendant, they are separate litigation. So in terms of like the process of like how, like the rules that have to be followed for discovery, it's different when she is being pulled into the Esme Bianco case because they have to serve a subpoena on her. So they can't just send her a request and say, "Hey, when are you coming?" Because it's much more informal where she's an active party in that case. But anyway, so they had served a subpoena. They had agreed on a date. They had August 17th. And that was important for that case, but then also important for Marilyn Manson's case against Evan Rachel Wood and Elma Gore, because if you've been following along on this channel, you know that there are a couple anti-SLAPP motions in that case. So they're trying to dismiss the meatiest portions of his complaint against these two individuals. And they're trying to use the anti-strategic litigation against public participation statute in California. And so he is now requesting the ability to request discovery and, so that he can pull in information and put those together in his opposition to those anti-SLAPP motions so that all those claims can survive and he can move forward with a litigation and move forward into substantive discovery against those two individuals. So he's made a request to do certain pieces of discovery. And in that, in those filings for the anti-SLAPP motions, one of the things that Marilyn Manson's attorney said is, "Hey, we haven't even included in this list of like what we're requesting here, because they have to be very limited about what they request for anti-SLAPP discovery. They're like, we're not even requesting the ability to depose Ashley Morgan Smithline because we're already deposing her in this other case. It's noticed for August 17th. We are going to have deposed her before the point at which we are supposed to file our opposition to these. So this is a deposition that is very important to Marilyn Manson's side. At least they are regarding this deposition as very important for them. And so it seems like Ashley Morgan Smithline has some information that they already think is going to be very important for surviving the anti-SLAPP motions and probably substantively for all of this other litigation that is, with Evan Rachel Wood, Elma Gore, Esme Bianco, and then obviously Ashley Morgan Smithline herself. So, anyway, so they had this notice on August 17th. And as it turns out, she didn't show up for that deposition. Jay Ellwanger, her I say her attorney at the time. Turns out maybe not. um, kind of a giving it away a little bit, but he was representing himself to be her attorney at the time. He said she can't come because she's at a psychiatric hospital in Los Angeles. Mind you, the deposition was supposed to happen over Skype. She was supposed to be in London. And I'm quite certain that Marilyn Manson's attorneys are in LA too. So that's a very interesting thing to claim. She's been living in London. She's flying on a 10-hour flight across the Atlantic Ocean and across the, all of North America just to go to a psychiatric hospital. Maybe there's a really good one that, is particularly good that she would want to go to or would be best for her. I don't know. But that explanation does sound a little bit strange. I'm not going to lie. And then, but the other side, they don't necessarily question it. They just say, okay, well, provide some kind of a note showing that she's there, that she's, that she can't come to the deposition because she has to check into, this psychiatric hospital. And also, by the way, you also are aware, Mr. Ellwanger, that you are supposed to provide documents for this deposition. So we're assuming this is the day before the deposition is supposed to happen. They get this notice from J. Ellwanger, from Ashley Morgan Smithline's attorney, saying she can't come because she's too stressed out. She's got, mental, emotional health issues that she just cannot possibly sit through a deposition right now. And so they're like, okay, well, you should have the documents by now, right? Which is that's a very fair and reasonable request, because it takes time to notice a subpoena or to serve a subpoena on a third party. You have to, there's a long runway between notice of when the deposition is going to happen and then when the deposition actually happens. So plenty of time for a document production, plenty of time for, for any kind of notice saying, hey, these are going to be too difficult to produce in time for that deposition. There's the communications need to happen if there's going to be any kind of an issue. So they're like, all right, so you were supposed to come tomorrow with these documents. We're assuming you have them, which is a proper assumption to have. And so then he says, okay, yeah, I'll give those documents right up. And as it turns out, he doesn't give the documents. It looks like there's multiple follow-ups. And then he also doesn't produce any sort of note showing that Ashley Morgan Smithline actually went to the psychiatric hospital. And so despite all of that, Howard King, Marilyn Manson's attorney, said, hey, okay, so we will extend a professional courtesy to say that we can push this back a little bit. So let's push this back from the 17th to August 30th. And we'll depose her then, after she's had some time to get whatever treatment that she needs. So then J. Ellwanger says in his in an email response after Howard King had followed up with him saying, hey, we're just making sure that your client is going to be able to be there for the deposition, like the next day. This is like the day before, a couple days before. And then, or no, this is on the 25th, 5 days before. J. Ellwanger then responds saying, nope. And for reasons of privilege, reasons of confidentiality, ethical reasons, I cannot tell you why. And the suggestion to that is, I talked about this in the last video, saying the suggestion is there are two possibilities. I'm so excited I can't talk. There are two possibilities here, right? There's the possibility that there's a medical reason, like a HIPAA related reason why he can't tell him, because it's her confidential. I talked about that's not likely, because if she's using her mental health or any kind of health reason for why something happened or something didn't happen, that usually opens the door for the other side to be able to examine whether or not that's actually true, right? So you can't claim a medical reason and then hide behind HIPAA when the other side asks for, information to try to validate it, right? So that didn't seem likely to me. The other possibility is client confidentiality between the attorney-client relationship, meaning that there was something that she had told him that uh that basically suggested that she had lied to him. That's what it sounds like, right? That she had been somehow dishonest. It's not supposed to mean I lied about my client. So it looks really shady. It looks really shady. And the reason why there's this new information, by the way, I should have mentioned this, is so in my last video, I mentioned how there were two motions that were filed. There was one motion filed in the Smithline case, one motion filed in the Bianco case. The motion filed in the Smithline case was the motion to withdraw, saying she breached the attorney-client she breached the retainer agreement. Interesting. I definitely would love to see the retainer agreement now, to see he even cites a couple paragraphs saying which ones that she breached, and saying that she had become unreasonably difficult. All of that looks like BS now. Based on what we've seen since then. And then anyway, so it's saying that for all of those reasons, he needs to now withdraw. And then in the Bianco case, he filed a motion to modify the subpoena, basically to say, hey, this subpoena was supposed to have her deposition beyond the 17th. She couldn't show up on the 17th. And so now we're requesting a 90-day, um, what's it called? A continuance on all discovery, so that, she has time to find new counsel, and if there's any kind of discovery requests, there's some due dates, and we want to make sure that she's not left in a weird, precarious position, because I, as an attorney, have certain professional obligations in withdrawing from representing a client, and so I can't leave them in a vulnerable position. So in the Bianco case, the new information that we have now comes from an opposition filed by Marilyn Manson's attorney, Howard King, saying, nope. Nope. This guy is misrepresenting, is the term that they use. Misrepresenting is a very classy way of saying this guy is lying through his teeth. He's a lying liar who lies. And okay. I think before I summarize more, I've spent probably enough time summarizing to sort of explain the whole thing about the situation. But there are receipts. There are receipts here. There are text conversations between Miss Smithline and her attorney, which ostensibly Miss Smithline has given to other people. Now, I will say, before we get further, there are certain professional obligations. If if you think text messages between Miss Smithline and her attorney, and you think attorney-client privilege, you're on track, right? Because communications between these two individuals are privileged. They are meant to be kept confidential. However, that is a privilege that is owned by the client, meaning the client can waive that. She can send any individual who is represented by an attorney can waive the attorney-client privilege by sharing those communications with other people, and so they are no longer privileged. Then they're free for anybody to look at or to hear, or whatever, if it's recorded in some way. So there are certain text messages showing that Mr. Ellwanger is representing to the court and to opposing counsel and to the world that he is withdrawing from representing Miss Smithline. But it looks like, from this new information, it looks like she fired him in April of 2022, which has all kinds of implications. All kinds of implications. And there are a lot of different communications that he has made to the court, to opposing counsel, and to Ms. Smithline that are questionable at best, in my opinion. Let's get into it. Okay. Here's the opposition filed by Marilyn Manson's attorney to the motion to modify the subpoena. Oh, and before I do get further into this, I'm going to say, so I don't know how long I will be talking about this because there are so many things that I can say about this. And I apologize if I'm a little bit like bouncing around a bit. It could be the full pot of coffee that I had today, or it could be just my excitement about like what the heck is going on here and wrapping my brain around it. Even with the last video that I did, there were a lot of thoughts that I had on that didn't make it into the video because you can talk about these things for a long, long time. There are all kinds of things that can come up. So I will be at noon East Coast time today. I will be on Eric Hunley's channel. I know Rob's going to be there too. And I know that the two of them just had a live stream last night about this issue and going through a lot of these documents and stuff. So I can't wait to talk to them about this. I just, my mind is just kind of blown. So if you guys want to see that conversation, be sure to join us. I'll link it. I'll link the video in the description once I grab it. I'm sure. I think Eric actually already posted it. But if Secret McSquirrel, if it is out on Twitter, if you want to drop it in the chat, that would be helpful. Anyway, okay, let's get further because I'm probably not going to be able to get all of my thoughts out on this in like within that period of time. And yeah, here it is right here. So yeah, check this out right here. So yeah, I'm probably not gonna be able to get all of my thoughts out on this, but hopefully I can do this in a way that is understandable and people can register like why this is such a big deal. Okay. All right. So defendant Brian Warner's opposition to motion to modify the subpoena. I'm just going to do a straight read through on this. And then I'll just give my thoughts as I go along. Okay, part 1, introduction. Non-party Ashley Morgan Smithline's. Oh, and just a reminder, this is filed in the Bianco case. This is why she's a non-party here. She's a third party. She's not a plaintiff. And yeah, okay. Non-party Ashley Morgan Smithline's untimely motion to modify the deposition subpoena served on her should be denied because the subpoena does not impose an undue burden on her purported and her purported counsel that filed the motion, J. Ellwanger, who remains counsel for plaintiff Esme Bianco, has apparently misrepresented Ms. Smithline's wishes and the reasons she could not timely comply with her subpoena. Okay. A number of these things. Purported counsel. Her purported counsel, her claimed counsel, the guy that says he represents her. The guy claims he represents her, but he doesn't. He doesn't really. This is what this implies. It's throwing just a little bit of shade, which is fun. He's apparently misrepresented Miss Smithline's wishes and the reasons she could not timely comply with the subpoena. He's lied to you, Your Honor. He's lying to the court. Miss Smithline's wishes and the reasons she could not timely comply with the subpoena. Yeah, it's just, yeah. Far from having any merit, the motion is a clear attempt by Mr. Ellwanger to buy himself time in light of the serious ethical questions arising from his withdrawal from representing Miss Smithline and his continued representation of plaintiff Bianco in this action, in which Miss Smithline is a key witness. Ms. Smithline's deposition was originally scheduled with mutual agreement of counsel for August 17th, 2022, and the witness appearing by Zoom from England. But in the afternoon on August 16th, Mr. Ellwanger urgently requested that defendants agree to postpone it because he said Ms. Smithline could not attend and was on a plane to Los Angeles to receive emergency psychiatric treatment. Relying on Mr. Ellwanger's representation, defendants agreed to continue to continue the deposition to the mutually agreed date of August 30th, contingent on Mr. Ellwanger's promise and agreement to provide a complete production of the documents requested in the subpoena by the end of the day on August 16th, which documents he said were already in his possession and ready for production, and to later provide a written note from Ms. Smithline's treating professional that she was unable to appear on August 17th. Now, a couple notes about this. Someone had asked in the comments yesterday on my last video about the agreement to provide a complete production, this part right here, which he said were already in his possession for reproduction or for production. Sorry. So someone had asked, like, is he really lying about this issue? And I cautioned them because I was like, I don't know. We're getting this information from emails back and forth between the two attorneys. Either side can be sort of blustering a bit, and when we're talking about like one of the attorneys characterizing what the other person said in an email that goes back and forth, you want to be careful about taking that at face value because of the fact that this is an adversarial process. The attorneys, there can always be a possibility that the attorney could be saying that and describing, what the other person said or did in a way that's most favorable to them, that isn't fully accurate, or that the other side at the very least wouldn't agree with. But here, this is Howard King making a representation to the court. This is Howard King making an argument on Manson's behalf to the court, which is different. It's different than just an email to the other side saying, hey, you said such and such and such and such, because there's no, not to say that there's no requirement for them to be truthful, but like, you can, I would say that you have a little bit more room to bluster and stretch things because that the other side is going to come right back and like, say that's not true or whatever, like you expect kind of the same of the other side. But here they're saying pretty much unequivocally saying that he said he had the documents already in his possession. Because yesterday I was like, yeah, I don't know. I'm in like nuanced territory here, right? Like I'm trying to read through these things and be like, I don't know if we can really go down the road of like concretely saying like, yeah, he said that the documents were in his possession, because that was just a characterization by Howard King of something that Ellwanger had told him, without seeing like what I basically said was like, I want to see the actual communication from Ellwanger to see if, if that actually is true, or if there was just some, like if he maybe said something that sort of hinted at it and seemed like, oh, I don't, like the other side just took that as, oh, you have it. I'm assuming you have it or something like that. But this is like I said, this is a representation to the court saying, no, he said he had possession of these documents. Mr. Ellwanger immediately broke his promises by producing only 4 redacted text messages on August 16th, which no person could reasonably believe was a complete production because these documents explicitly refer to other responsive communications that were not produced. Defendants informed Mr. Ellwanger of this, but he has made no effort to supplement the production. So basically saying, and this is part of discovery. I've dealt with this before, where you make a request for documents of the other side, and they say yes, we'll produce, and then they send over like a few documents, and you're like, there were 30 requests here, and each of those requests like kind of refers to like a series of documents. There's a lot more that should be here. Like this is not responsive to everything that we requested, and you didn't object to XYZ. So it's like when that happens, yeah, I'm pissed if I'm on the receiving end of those documents, right? Because I'm like, here I am expecting a full production. The other side doesn't say like, hey, we're having trouble. Like, hey, I need a little more time to gather all of the documents that you need and that you're entitled to. Like, that's normal. That's normal, and that's something that would be expected, sometimes expected, but like reasonable and allowable, like I can respect that when I'm the counsel that's requesting those documents, and the other side is just having a hard time, either because they're trying to coordinate with their client, or they're trying to go through and make sure that there's no confidential information that needs to be redacted, properly redacted. So yeah, if you make a documentary request and the other side doesn't give everything that's responsive to all of your requests, you are entitled to fight about that. So okay, anyway, let's keep going on. Mr. Ellwanger also never produced a medical note to substantiate his representations that Ms. Smithline was unable to attend her deposition on August 17th. Instead, he has since filed a motion to withdraw as Ms. Smithline's counsel in her separate case against defendants. And the day before Ms. Smithline's rescheduled deposition in this case, he filed the present motion to modify the deposition subpoena to provide Ms. Smithline 90 days to secure a representation by new counsel. But what's worse, after Mr. Ellwanger filed these motions, Ms. Smithline unilaterally emailed defendant's counsel communications between her and Mr. Ellwanger, which she has also distributed to third parties online, showing not only that she was never coming to Los Angeles for emergency medical treatment or undergoing treatment elsewhere, but also that she fired Mr. Ellwanger months earlier in 2002. That's bad. Bad for Ellwanger. Really bad for Ellwanger. Like, if this is true, he lied to everyone. He lied to the court. That's a no-no. I mean, to say that that's a no-no is like so small. Like, that is your professional reputation that you are just throwing into the wind and just being like, whatever, court. Oh my God. Like, I can't, it blows my mind. Whenever I am looking at these attorneys in these cases, and especially one who I'm embarrassed to say went to my law school. Mr. Ellwanger apparently also went to University of Texas long before I went. So because when I looked him up, I was like, oh, cool, hook 'em. Now not so cool. But but anyway, I can't remember where I was going with that. I got distracted by my own thoughts, but like, oh, it's just bad. Oh, so I never want to like assume that these attorneys are unethical or incompetent or anything. Like I always want to assume that they are doing the best that they can and that they are just being ethical attorneys, whether it's because they're good people or more likely because of the fact that there are certain rules in place for licensure, which have some very harsh penalties oftentimes, whether it's monetary sanctions or sometimes going so far as losing your license. Um Misrepresenting to the court that you are representing a client that you are actually not representing is one of those things that can really, really land someone in some hot water. Like that's a really big one. That's a really, really big one. Attorneys will make mistakes just like anybody else, right? It is sometimes your zealousness will get the best of you, for example, or something. I don't know, or you slip up in some way, miss a deadline, things like that like keep an attorney up at night or like make you like suddenly gasp in the shower because you're like, oh my God, did I miss something? Those are the kinds of things that you can still get into trouble for. But like that's why this is just, it boggles the mind. Okay, let's continue. Let's continue reading. Okay. Ms. Smithline added that for a Me Too lawyer, Mr. Ellwanger doesn't listen to the word no. Oh, God, that's so bad for him. In response, defendant's counsel informed Ms. Smithline, copying Mr. Ellwanger, that as long as J. Ellwanger is your counsel of record, I am not permitted to communicate with you absent his consent. Ms. Smithline responded, stating unequivocally, with Mr. Ellwanger still copied, that she had fired Mr. Ellwanger and he is lying. And he is lying. So I did see one thing about this is that I did see on Twitter some people being like, well, maybe he just didn't take her seriously. This is a serious matter for attorneys when it comes to the professional rules of conduct in any state. So when you are licensed as an attorney, maybe I'll back up a little bit. When you're licensed as an attorney, in every state in which you are licensed, you are bound by the rules of professional conduct in that state. So the CRPC, the California Rules of Professional Conduct, bind the things that I do and the ways that I work as an attorney if I'm representing clients or doing other stuff. So, and the same thing, I'm licensed in California and DC. I'm also bound by the DC rules. Mr. Ellwanger is licensed in Texas and California. So he's bound by both sets of rules here. And the thing about those rules is that, like I said, they have very harsh penalties. So if there's any sort of ambiguity, if the attorney gets a communication from a client and the client says, I no longer want you to represent me, if there's any ambiguity to that, the lawyer can't just like walk around and be like, oh, you don't mean it. you don't actually mean it. I'm still going to represent you. Like, I know that you're lying. I know that you're just kidding. You can't, the lawyer can't just like take their own interpretation of that and like continue on with business as usual. If there's any ambiguity, it's up to the attorney to get clarity from the client to say like, do you actually mean that? Because like, and you can explain to them like, okay, if that's what you want, this is what's going to happen. I have to do XYZ. I need to make sure that this is the case. And most attorneys, the ones who are thinking properly or maybe thinking at all are they're going to get that in writing because it's better for the attorney to have that clarity. Yeah. Yeah. I mean, it's so as an example, if I'm fired by a client, over the phone and they say like, hey, uh, this is my name is such and such. You've been representing me, and I'm not happy with your representation. So I'm gonna go elsewhere. I don't want you to represent me anymore. You send an email afterwards between you and the client. You have certain email correspondences. You've got emails going back and forth between the two clients, and you're generally speaking going to confirm that in writing to say, hey, okay, so we just had this conversation over the phone. You said you didn't want me to represent you anymore. I explained to you XYZ, and this is the result. So I will be filing a motion to withdraw as soon as possible. In the meantime, you have such and such deadlines. I recommend that you find new counsel so that you can have those covered. I'll do whatever I need to make sure that your things are. There are certain steps that ethically would be required of the attorney. If we're talking about active litigation, they have to get permission from the court. Generally speaking, it depends on the jurisdiction, but almost every jurisdiction that I know of would require the attorney to get permission from the court to withdraw. If it's like long before trial, like at this stage of litigation, the court generally speaking is probably going to allow that attorney to withdraw, regardless of whether or not there's another attorney waiting on the wings to represent this person, because people do represent themselves. It's not not generally advised because there are so many pitfalls that can happen. There's a lot of process. I mean, even you can just get stuck in the weeds of like the process of how to litigate a case. And so somebody who hasn't been trained on the laws, it's incredibly difficult for anyone to represent themselves, and just also the psychological emotional aspect of it too. Anyway, but like, so people do represent themselves. There doesn't have to be some other attorney waiting to represent this client for after this attorney leaves. But anyway, okay. So anyway, all of that is to say that if there's any ambiguity, a lawyer can't rely on that and say, "Oh, this they were just kidding. They were just kidding." I can just ignore what they said when they said that they didn't want me to represent them anymore. um, okay. Let's continue. Thus, contrary to Mr. Ellwanger's arguments in the motion that Ms. Smithline will be prejudiced absent a 90-day continuance to find new counsel, Ms. Smithline is conducting herself as if she wishes to proceed on her own, which is not uncommon with third-party subpoenas. There is no evidence she wishes to retain new counsel or postpone the deposition, nor is there evidence to justify Mr. Ellwanger's delay in waiting until August 29th, the day before the rescheduled deposition, to file the motion based solely on his quote unquote withdrawal, quote unquote withdrawal, because this is more shade right here. These quotations right here saying he's calling it a withdrawal, but is it really? Because he's been fired long ago. Withdrawal, given Miss Smithline's repeated statements that she fired him months earlier. Even taking Mr. Ellwanger's word that Miss Smithline assented to his termination on August 19th, the motion is still untimely. He cannot justify waiting more than a week after Miss Smithline reconfirmed his termination as her counsel, blithely ignoring the extensive preparation defendant's counsel had to undertake and the many requests for Mr. Ellwanger to confirm whether Ms. Smithline was appearing for the rescheduled deposition. The motion should be denied and Ms. Smithline's deposition should be ordered to proceed forthwith. Let me get a couple super chats here. Thanks, guys. IULLIAB, Euliab, maybe, perhaps. Thanks so much for the super chat. It says, why would Jay Ellwanger continue to act as a lawyer after he was fired? Is there anything he could gain from it? This is something that I'm gonna have to kind of sit and think about for a little bit. Maybe it'll come to me in the next live stream when I'm on Eric Hunley's channel. But there are multiple possibilities. I mean, it would have to serve him in some way, right? Because it could be that by maintaining some level of control over her deposition, he can delay it out. He can't, it wouldn't be able to be delayed forever. So like at some point, I mean, this is why like the idea of the attorney lying to opposing counsel came up in my last video, and I kind of discarded that because I was like, why would he lie about her being in a psychiatric hospital? Because like it's such an easy thing to get caught on, right? Like it's such a stupid thing to lie about when you're the lawyer. But crazy, right? But my point with that is that at some point she has to sit for a deposition. And I said this yesterday too. I don't know. The best that he would be able to do is to delay her deposition long enough until they can settle the case, write it out for Evan Rachel Wood and Ilma Gore and their anti-slap deadlines to pass. I don't know. I'm not entirely sure why he would want to, but it seems like it would be serving the other cases, to delay that. I don't know. But it's such a good, that's a good question. It's a really good question. Marion Williams, thanks so much for the super sticker. Thank you. And Uncivil Law says, I write you on behalf of my client, Legalbytes. You're not my attorney. You don't represent me. Thanks, Kurt. I appreciate that. So, oh yeah, I just this question of why, I don't know. I don't know, man. I don't know why he would, because I almost wonder if maybe the they thought that they could file these cases against Marilyn Manson and think, okay, there's no way he can afford representation on all of these because lawsuits are really expensive, as we know very well from the Depp v. Heard case. And that was a huge figure, but Manson's got some big firms representing him here. He's paying a pretty penny for these. So it's almost as if they didn't anticipate that he would actually say, you know what, I'm going to fight my way through this. And maybe they figured they could get quick settlements and not have to go through the discovery process. I don't know. I'm not sure. But I've been trained by my mentors in litigation to say that you prepare every case that you file as if it's going to trial. Don't ever file a case thinking we're not going to have to do discovery. So if that's what they were thinking, I don't, it's foolish. It's incredibly foolish. Okay. Let's continue here. Okay. All right. Let's go on. Part 2, factual background. Subpart A, multiple women falsely accused Mr. Warner of abuse in early 2021. Now, remember, this is an opposition that's filed by Marilyn Manson's side. So the facts that are alleged here are going to be they're going to be framed in a way that is most beneficial to Marilyn Manson. So let's see what they say in this particular case. Mr. Ellwanger represents Miss Bianco in this action and purports to have represented Miss Smithline in the action filed against defendants captioned Smithline v. Warner et al. Mr. Ellwanger was referred to Miss Smithline by Miss Bianco. That's interesting. That is interesting because if there's some unethical stuff going on here, it brings up a lot of questions about his role. Anyway, interesting. Miss Smithline claims the abuse took place in 2010 and Miss Bianco in 2011. Miss Bianco, Miss Smithline, and other women who simultaneously emerged with false allegations of abuse in early 2021 have stated in court filings that before making their public accusations against Mr. Warner, all based on acts alleged to have occurred as much as 10 or more years earlier, they met and spoke with each other, often as a group, regarding the accusations they would make. See, for example, document 18 at 12, plaintiff did not recognize the true extent of her psychological injuries, nor that the actions committed by defendant constituted sexual assault and sexual battery until meeting with other victims and speaking about her abuse in 2020. Sorry, let me just capture these super chats here. So, okay, so they're saying that they didn't recognize that it was abuse, that it constituted sexual assault and sexual battery. Okay. That's something that does happen to victims. So different from the whole, gap in memories issue that we talked about when I had Dr. Honda on the channel. And then also citing to Smithline v. Warner et al. The true extent of the injuries suffered by Miss Smithline were not fully realized until fall 2020 when she began meeting with other survivors of Mr. Warner's abuse. And the reason why this was probably alleged in these other cases is because of the fact that these incidents were 10 or more years ago. And so there's an issue of statute of limitations. And I understand that Ashley Walters' case against Marilyn Manson was dismissed on that ground, on the grounds of statute of limitations. I also understand that I think she's appealed it, but so I don't know where exactly that is or where where that is in the process specifically, but yeah, interesting that they've been able to sort of argue, sort of extend that reach of the statute of limitations a little bit based on the damages or based on their perception of what had happened. Part B. Mr. Warner subpoenas Ms. Smithline in this action. On July 1st, 2022, Mr. Ellwanger agreed to accept service of a subpoena on behalf of Ms. Smithline in this action. Mr. Warner's counsel asked Mr. Ellwanger to confirm he still represented Ms. Smithline, given that in May, Ms. Smithline left voicemail messages for Mr. Warner's counsel stating she fired Mr. Ellwanger, who she referred to as her former attorney. Whoa! In May. Okay. Interesting. Mr. Ellwanger responded that he still represented Miss Smithline. That's a straight up lie, it sounds like. It could be. Now, mind you, there could be a third option here, right? It could be that Miss Smithline was really pissed at Mr. Ellwanger, called opposing counsel and said, he's no longer my attorney. And left a voicemail for that. And then the next day, they had another conversation and he said, I'm sorry. I'd love to have you back or something like that. Like, will you have me back? Kind of like a breakup and getting back together kind of thing. That can happen. It could be. It could be. It could be that Miss Smithline is sort of up and down with her relationship with Mr. Ellwanger. Or maybe she's just being very consistent and saying, no, I fired you in April. Like, we're no longer together. And then he's saying, yeah, no, but I'm going to represent you anyway. And I see in the chat, look at the attachments. We'll get there. I want to go through the arguments first. Okay. On July 12th, Mr. Ellwanger stated that Ms. Smithline would be available for a video deposition on August 17th. Accordingly, Mr. Warner served the subpoena for an August 17th deposition. The subpoena included a single document request, all written communications with Esme Bianco, Evan Rachel Wood, and or Ashley Gore, aka Elma Gore, regarding Brian Warner, including but not limited to text messages, email, social media messages, and any other direct messages. Ms. Smithline did not provide any objections to the subpoena. No objections. Ooh, okay. No objections at all. On August 10th, counsel for Mr. Warner emailed Mr. Ellwanger asking whether all responsive documents would be produced at least 48 hours before the deposition, which is common. Because if you are going to depose someone and you've also requested documents from them, you want a chance to be able to look through the documents that they're provided so that you can ask them questions about it. You don't want to waste everybody's time by sifting through those documents while that person is there, because then you're also eating away at your own time as the attorney that is asking the questions in the deposition, because they're only required to be there for a certain amount of time. Like, you can't keep this person there forever at a deposition. Mr. Ellwanger never responded. Part C, Ms. Smithline postpones on less than 24 hours notice. On the afternoon of August 16th, Mr. Ellwanger called counsel for Mr. Warner and stated that Ms. Smithline would not be able to appear at her deposition the next morning due to medical reasons, quote unquote, which Mr. Ellwanger explained meant she was flying to Los Angeles to receive treatment for, quote unquote, emergency psychiatric issues. In exchange for Mr. Warner's agreement not to require an emergency motion for protection, Mr. Ellwanger agreed to reschedule the deposition to August 30th and promised to provide, 1, Ms. Smithline's complete production of documents by August 16th, and 2, by August 30th, a written report of her treating professional confirming that Ms. Smithline was medically unable to appear tomorrow and setting forth any further purported restrictions, including the basis, therefore, that might affect her ability to sit for deposition on August 30th. Part D. Ms. Smithline fails to comply with the subpoena's document request. On the afternoon of August 16th, Mr. Ellwanger's office produced documents purportedly on behalf of Ms. Smithline. However, the production was facially deficient. On its face, it was deficient. We could tell just by looking at it that this was not everything that we were requesting. This couldn't possibly be. And we could tell right away. That's what that means. The mere 76 pages of documents comprised only 4 text message chains involving Miss Smithline and Miss Bianco, 2 of which were Miss Bianco's, not Miss Smithline's documents. Indeed, the documents bore Miss Bianco's bait stamps. There were no emails and no communications whatsoever between Miss Smithline and Miss Gore or Miss Wood, and the documents themselves internally referred to other communications Miss Smithline did not produce. Further, over a dozen pages contained redactions, and on August 17th, Mr. Ellwanger's office provided a privilege log for only some of the redactions, which purported to claim attorney-client privilege over communications between Miss Bianco and Miss Smithline without any attorney. Ooh, okay, multiple things here. When you have redactions on discovery, generally speaking, you're supposed to provide a privilege log. A privilege log is just like it's like a spreadsheet basically that says that that identifies the document and the page or whatever, and you say like, there's certain information that was requested, certain information was redacted, here's the reason why. Like you're supposed to you're supposed to do it in a very organized fashion, so you don't just like block out a whole page of text and say like, oh, this is confidential for reasons. So that's what you're supposed to do there. Also, if there are certain redactions that purport to claim attorney-client privilege over communications between Miss Bianco and Miss Smithline without any attorney, that's not the attorney-client privilege. The attorney-client privilege has to involve at least an attorney, and it's between client and attorney. So not between client and client. Communications between 2 clients, you can't just like shield those communications because they're both represented by the same attorney. That's not how that works. That's not privileged. It's privileged if it's a communication between the client and the attorney. And the reason for that is to promote and to encourage the client to tell everything to their attorney. I talked about this in the last video that I said this is the whole purpose, right? Is so that the attorney tells, or so the client tells their attorney the truth, the whole truth, nothing but the truth. Give them everything, the good, bad, and the ugly, because you want your attorney to know of all of the facts, whether they are good, bad, or indifferent, because you want them to be able to respond to the various facts, whether they are good or bad, that are going to be used against them, right? Like you want to have a strategy in place for them so that you know how you want to litigate this particular case. Because if you have certain facts that are so bad that it would potentially nuke the case, you want to settle it really quickly at a really low number. I have seen those cases too, where we get discovery requests from the other side, and then we turn to the client and say, hey, do you have information responding to such and such? And then they say, I want to talk to this one attorney here on their own, and maybe not you, even though you work at the same firm and everything. And like, telling them is telling you, but like, I feel kind of sheepish about this. I don't know what to do, whether we should respond and tell the other side this, but here's some XYZ information that's really bad for my case. And then you say, oh, we are required to tell the other side that. We are required. That's not something that we can keep from the other side. And that's terrible for your case. So let's settle it right away and make this case go away. Why did you file it? Why didn't you tell us this at the very beginning? That kind of stuff happens. Okay. Anyway, I'm totally going down another like rabbit hole. Continuing on with this. We're already like an hour into this live stream, and I know I've got a 2-hour cutoff because I've got to go on to Eric Hunley's channel. On August 17th and 18th, Mr. Warner's counsel asked whether Mr. Ellwanger served the complete production he had promised. Mr. Warner's counsel also asked whether Miss Smithline was in fact in Los Angeles, as it appeared from her Instagram account that she was still in London. Yeah. That's that would make me ask the same thing. Mr. Ellwanger responded, stating the 4 chats and privilege log were responsive to the subpoena. Basically saying this is all the information that there is. The other thing about this, by the way, is that the kinds of communications that he did provide were between Miss Smithline and Miss Bianco. What that tells me is he probably happened to have those because he got those from Miss Bianco, because he still represented Miss Bianco, right? So he probably had those for purposes of discovery with her. So there's a reason why he didn't have any communications between Miss Smithline and anyone else, because he couldn't get those because he didn't represent her anymore. Oh my God. This is just wild, you guys. This is crazy. Okay. I am losing my mind over this right now. On August, oh wait. Uh However, he could not confirm that these were the promised complete production. Oh, okay. So he couldn't promise that they were everything. Never mind. So I take that back from earlier. Mr. Ellwanger also stated in response to the question about Miss Smithline's whereabouts, I already told you she's in Los Angeles. On August 24th, counsel for Mr. Warner emailed Mr. Ellwanger explaining the numerous deficiencies in Miss Smithline's document production, including the missing documents and baseless claims of privilege. He asked Mr. Ellwanger to confirm Ms. Smithline would, one, supplement the production no later than Friday, August 26th, including to provide unredacted documents, and two, appear at her rescheduled deposition on August 30th. Mr. Ellwanger never responded to this email. Not good. Not good for Mr. Ellwanger. Part E. Mr. Ellwanger fails to substantiate the supposed August 17th emergency and refuses to confirm whether Ms. Smithline will attend the rescheduled deposition. On August 25th, Mr. Ellwanger emailed counsel for Mr. Warner stating that for reasons which I am ethically required to keep confidential, I cannot provide the written assessment from Ms. Smithline's treating psychiatrist, which Mr. Ellwanger previously promised. Mr. Ellwanger further stated he was going to have to file a motion to withdraw as counsel for Ms. Smithline. However, he would not answer whether Ms. Smithline still intended to sit for her rescheduled deposition or whether she would supplement her deficient document production. Yeah, we read through that email in the last video. Part F. Mr. Ellwanger seeks to withdraw after significant delay, confirms Ms. Smithline will not appear at the rescheduled deposition, and seeks relief from the court on less than 24 hours notice. On Saturday, August 27th, Mr. Ellwanger filed a motion in Smithline v. Warner et al., seeking to withdraw as counsel for Ms. Smithline. Mr. Ellwanger claimed Ms. Smithline's conduct has rendered it unreasonably difficult for counsel to carry out the representation effectively, and she breached paragraphs 9 and 16 of the retainer agreement. I'm wondering if like his like when he says that her conduct has rendered it unreasonably difficult for him to carry out the representation, that maybe what he means by conduct is she fired me. Because firing him would also make it unreasonably difficult for him to carry out representation of her effectively, right? Like that's not what that's supposed to mean, but like maybe he's like, yeah, like we'll call it that. She breached paragraphs 9 and 16 of the retainer agreement. Man, I said this earlier in this live stream, but I would love to see the retainer agreement. It's we're probably not going to see it because it's generally kept confidential. Unless Miss Smithline decided to like really burn the ships and just like post it on Instagram or something. It's always possible. He did not attach the agreement or explain what this meant. Mr. Ellwanger further stated Ms. Smithline knowingly and freely assented to termination of the representation on or about August 19th, 8 days earlier. Which, if I'm an attorney, I am an attorney, but if I'm an attorney in active litigation and my client fires me and I know that there's a deposition that's supposed to happen 8 days later, I'm telling the opposing counsel like right away, say, hey, this needs to be taken off calendar, or at least like I'm in a bind here because I've just been, let go, or I'm no longer, you don't have to say that much detail. You can say I'm no longer representing this client. So I know that there's a thing, I want to make sure that their interests are protected as I withdraw from representation. I'm letting them know right away, because that's how you protect their interests in withdrawing, is by informing opposing counsel to give them notice that there are certain interests that need to be protected for this person, because they're aware of the ethical responsibilities of the withdrawing attorney, because giving professional courtesies is part of the game here. So the fact that he didn't tell Howard King that he had been fired right away, even if it's on the 19th. Let's say it's on the 19th and not April. I'm telling them on the 19th that I'm no longer representing this client. Not the day before the second day of the deposition, like the pushed back day of the deposition. Okay. I'm getting worked up. On August 29th, Mr. Ellwanger asked to take the August 30th deposition off calendar on the grounds that he sought to withdraw his counsel. When Mr. Warner's counsel would not agree, Mr. Ellwanger stated incorrectly he intended to file a motion for protection, which operates to stay compliance with the subpoena, so Ms. Smithline will not be appearing tomorrow. That's not what that does. That's not what that does. Yeah, no, they're right that this is incorrect, because when you file, so we've seen in the Manson case against Evan Rachel Wood and Ilma Gore, the use of an ex parte application. There are certain things that can be done to try to get an emergency decision from the judge on something, to like file something really quick and get in front of the judge and get a decision from them. This is in federal court, so the operation of something like an ex parte application, I'm very familiar with them in state court, less so in federal court. But there are, here we go. Instead of filing an ex parte application that could be promptly adjudicated, Mr. Ellwanger filed a regularly noticed motion on August 29th, seeking to continue the rescheduled August 30th deposition. In it, Mr. Ellwanger argued it would be an undue burden for Ms. Smithline to appear on August 30th pro se, or with Mr. Ellwanger as her counsel. He provided a declaration nearly identical to the one attached to his withdrawal motion. Okay, yeah. So he's not even freezing the discovery right. Okay, part G. Ms. Smithline fails to appear on August 30th and tells Mr. Warner's counsel she fired Mr. Ellwanger months ago. Crazy. On between the afternoon of August 29th and the morning of August 30th, after Mr. Ellwanger filed his motions, Ms. Smithline sent a number of communications that cast serious doubts on Mr. Ellwanger's timeline of events and his multiple representations to counsel for Mr. Warner that Ms. Smithline could not attend her August 17th deposition because she was in Los Angeles receiving medical treatment. Oh boy. Ms. Smithline sent a number of Instagram messages to a third party stating she fired Mr. Ellwanger in April 2022. In these communications, she shared screenshots of text message exchanges between her and Mr. Ellwanger from April 2022, in which she stated, "I am looking to discharge you. Please let me know when it's done and what needs to happen." That sounds pretty dang clear. That doesn't sound ambiguous at all to me. That sounds like somebody is saying, "I'm done with you. I'm done with you. Goodbye. What do I need to do to get rid of you?" Ms. Smithline also called Mr. Warner's counsel's office, stating as soon as he picked up that she fired Mr. Ellwanger in April 2022. And Mr. Ellwanger had not been truthful about why she was not produced for deposition. Wow. It's citing it at Exhibit 1. Mr. Warner's counsel emailed Mr. Ellwanger informing him of the unsolicited phone call and asked whether Mr. Ellwanger would consent to him speaking directly to Ms. Smithline, which he would not. That sounds about right for the vibe. Ms. Smithline also emailed counsel for Mr. Warner and shared with a third party on Instagram copies of text message conversations between herself and Mr. Ellwanger. Ms. Smithline expressed shock that Mr. Ellwanger told Mr. Warner's counsel she could not attend the August 17th deposition due to a medical emergency. Ms. Smithline, a model, responded, "What? I had to shoot for our hotel. He's a lying liar." Lying liar who lies. Oh my God. In the screenshots of messages she shared, Ms. Smithline told Mr. Ellwanger on August 22nd, a week earlier and 5 days after the original deposition, that she could not get a letter from her psychiatrist validating Mr. Ellwanger's excuse because I've been in London since March, not under the care of a therapist, and to stop lying, stop. I wasn't in LA for an emergency health session. Stop lying. Oh, this is really bad for Ellwanger. And presumably regarding the attached messages showing her request to discharge Mr. Ellwanger months earlier, she stated, for a Me Too lawyer, man doesn't listen to the word no in it. Mr. Warner's counsel copied Mr. Ellwanger on his response to Mr. Smithline, which stated, I know you told me that you were no longer represented by counsel, but as long as Jay Ellwanger is your counsel of record, I am not permitted to communicate with you absent his consent, which is correct. That's about all that they can respond. That's about all that they can say, and copying Mr. Ellwanger on the response is also appropriate. I mean, you that's what you should do. I know that Rob said on Eric Conley's channel yesterday that what he would do is just talk to the opposing counsel and like not respond at all. But this is I think also appropriate because of the fact that he put the attorney on the CC line. So this is not like the whole purpose of these communications, the rules on these kind of communications. Oh, and let me back up and explain this for a sec. Because when an attorney in active litigation knows that another individual is represented by another attorney, they cannot have direct communications with that person. They have to go through the attorney. And the reason for that is because you can start to have some shady lawyers trying to work around the opposing party's lawyer to like try to convince that party or to try to intimidate that party or do all kinds of funky things that are so not okay. So that's why there are rules for when a party has, when they know that someone is represented by a lawyer, they have to communicate through that lawyer. So communicating in the presence of that lawyer could be okay. So for example, like, I've many attorneys that have been litigators have gone to a hearing with their client or maybe even trial with their client and had like a communication. You see in the hallway the opposing counsel and their client or whatever, and like it's not like you can't say hello to them, right? If everybody's there, then it's okay to like have some kind of like general conversation. Because there's no threat of like you trying to work around the opposing counsel. So like this with responding to her saying, if in fact he is representing you, I can't talk to you. And also, by the way, he's your counsel of record. He needs to be taken off as your counsel of record. Until that point, I cannot talk to you directly. Saying that to her, especially with him on the CC line, like that's all above board in my book. Despite multiple cautionary warnings by Mr. Warner's counsel that he could not speak to Ms. Smithline as long as Mr. Ellwanger was her counsel of record, she continued to send emails. And by the way, counsel of record means that it's he's on record in the docket, like with the court. The court says, who do I communicate with to communicate with this party? Oh, I communicate with this attorney because this attorney is representing her. And so in order for that to change, a motion for withdrawal has to be filed. Copying Mr. Ellwanger, Ms. Smithline stated, short of me saying you're sacked and I fire you, what can I do? She also stated again, copying Mr. Ellwanger, do you see how he's lying? I would trust a fruit bat more than him. And this sucks. This sucks because you have a client who is basically in purgatory, essentially. Like that's what's going on here. She's stuck. She's already told him, yo, you're fired, you're gone, you're done. I don't want you to be representing me anymore. You are not to be speaking for me anymore. And then he says, yeah, shh. And then he goes over there and continues representing her. And he communicates to opposing counsel as if he's representing her. He communicates to the court as if he's representing her. And for her, like, the requirement is he's supposed to withdraw as soon as that happens. He's supposed to get himself off as counsel of record because there's so many things that can go wrong there. So I can feel the frustration from her because of the fact that she's like, what else am I supposed to do? What am I supposed to do? And the thing that is, I think that the thing that would have pushed him out would be her hiring another attorney, because then another attorney would say, okay, if you fired this other guy and he's still on his counsel of record, why? I'm going to communicate with him saying she wants me to represent her. So, let's get you off. We'll get me on, and, I'll continue. I'll take the file over from her, or from you, or whatever, from you, the attorney who had been representing her. So like, that's something that's I think what would have happened in this case if she had found another attorney in April or May or June or July, any of these months, right? But I wonder if maybe she fired him and then maybe figured, like, I don't have to do anything in this case anymore or something. I don't know. I'm not really sure what her thought process was. We can't suppose that without this information, but I can feel that frustration because she doesn't understand the process. Most people don't. If you're not a lawyer, if you're not a litigator. Okay. Anyway. It's just it really sucks. I feel like she's been taken advantage by this attorney here. Okay. And then we've got the legal standard. Let's get to motion to modify the now thrice violated subpoena should be denied. I mean, yeah, usually you can ask for extensions, you can ask for things to be modified, but generally speaking, you've got to do it before that deadline has passed. Otherwise, you've just missed a deadline. You can't extend a deadline that you've already missed. Okay. Yeah. So we're not going to get to the actual arguments of this motion, because I think that the most interesting parts of this are and I know that folks in the chat have been saying, like, show the exhibits. Show the exhibits, woman. We want to see the receipts. Let's get to the receipts. Here's the declaration of Howard E. King in support of defendant Brian Warner's opposition to motion to modify the subpoena. The receipts. Howard King brought them. So here he's got, I mean, most of this is listing exhibits A through Q, which he has referenced elsewhere in the motion. This declaration, by the way, is anytime you have a motion or you have an opposition to a motion, you are asserting certain facts. And so for those facts, you have to give some kind of support. That's what these declarations do. So if anybody is wondering, these declarations are basically saying, like here are the facts of such and such that support my argument here. And the reason why that's given weight is because at the bottom of the declaration here, right before they sign and date, is this right here. I declare under penalty of perjury that the foregoing is true and correct. You basically are swearing yourself in as a witness to these facts. So that's why I give information that comes in the either in the declaration itself or attached to a declaration. I give good credence to that because of the fact that it is essentially like this, like Howard King has basically gone up on the witness stand and taken an oath to tell the truth, the whole truth, and nothing but the truth, because it's under the same penalty of perjury. So he says here, on May 15th, 2022, I received 2 voicemails on my office phone. The caller identified herself as Ashley Morgan Smithline. She said she, quote unquote, fired her former attorney, quote unquote, and wanted to speak to me. I did not speak with her. I searched the number and it appeared to be associated with Ms. Smithline based on public records. Okay. So basically he's saying, I verified it was her. It was her. And I didn't talk to her. I didn't, it was basically, sorry, this is what I keep thinking, right? When we're talking about like attorneys talking to clients, not talking to clients. This is what I always think of. Like Arrested Development.
How much clearer can I say? There's always money in the banana stand. No touching. No touching.
No touching. No touching. No touching. No talking to this client. Sorry, that was just I'm amused by it. I love Arrested Development. Anyway, let's go back to it. Okay. Oh gosh, where do we start? Let's just get right to the messages here. Okay. First, so there's those, but let's get to the other ones first. Let's see if I can find them here. Oh, here's a communication between them. Okay. All right. We are okay. So this is I think from Instagram is what was indicated. We don't know who's on the our side of this, right? The purple is like the person who owns the account is communicating with Ashley Morgan Smithline. We don't know who that is but we can see that they are communicating with Ashley Morgan Smithline, assuming of course that it hasn't been doctored in any way. Let's see here. I see some questions here that I want to that I want to respond to. All right, I'm going to save them. Okay. Okay. So she says, I fired him in April. So, and then the response is, so what was he just lying and using your name because of the other lawsuit he has? God, I hate this guy. And then she says, I checked him in April. And these are videos, it looks like, of her kitchen. And then she sends this person screenshots of another text conversation. Sends it. Okay. And then she says, no, because I fired him and he had to look good. Oh my God, this is nuts. F him. I have to read these. Holy shit, I just read all this. He is such an a-hole. Spread the word. Who do you want me to tell? Okay. And these are the text messages that she had screenshotted and sent to this other person. These are between her and someone named Jay. Purportedly Jay Ellwanger is the assumption here. So from Jay, it says, Ashley, it's not that simple. You have a federal court lawsuit pending. I'm not sure who is writing these text messages, but it doesn't sound like you. We need to speak on the phone. It may not sound like me because I've put up with all of this for too long. Please put in writing why it is not that simple. And then he says, I just tried calling you. I need to speak to you on the phone to verify that your number has not been hacked. Given the past situation with your stalker and the complete change in your position after over a year of representing you, I am uncomfortable communicating with you further via text. And then she says again, please explain in writing why that's not that simple. I am making these statements on my own. I'm at a, and then it gets cut off. Okay, so he says, and then he says something, and then a plaintiff in a federal court lawsuit. If you fire me, you'll have to hire another lawyer to replace me or represent yourself pro se in the lawsuit. That is true. One of those two options. And the judge would have to approve any motion to withdraw as your lawyer. I mean, that is true too. I don't care about the media and your case. I don't care about the media and your case. Is that him saying he doesn't care about her case? That's what it looks like. You wanted me to find a producer and director to do a documentary movie about you. So I did. They emailed me today, by the way. The CNN piece is off because they are shutting down CNN Plus. You went to People magazine before you ever hired me. So if you don't ever want to speak to the media again, I'm fine with that. I don't care about that. But you are right in the middle of a lawsuit, so firing me is a little more complicated than sending a text message. No, it's not. For her, it's not. For you, it is. But for her, it's not. And I'm honestly very concerned about you. This is all very different. And then it gets cut off. Okay. And I am honestly very concerned about you. This is all very different behavior than I've ever seen from you, and I've known you for over a year. For example, you have never once said a word about caring about money in this case. And for the first time, you asked me when you were getting another check. And then she says, I am looking to discharge you. Please let me know when it's done and what needs to happen. And then he says, do you have replacement counsel? I need to be able to represent to the judge who is going to be taking over your lawsuit. No, he doesn't. Not really. No. No. He doesn't. He can so he has a responsibility at the moment that this is pretty unambiguous, by the way. Looking at these text messages, she's saying, I want to fire you. I'm done with you. Goodbye. I like what let me know when it's done and what needs to happen. What is so not simple about this situation? What is so not simple about sending you a text message saying that I'm firing you? So uh, the problem that I have with this is like he's just fighting with her about firing him, which he is in a very self-interested place to not be fired, right? Because he has presumably dedicated some resources towards her case, towards representing her in the Bianco case. That does cost money for the attorney. So maybe he's worried about like, okay, like, I need to have my costs paid for. The thing about that is that even that, the retainer agreement, I don't know what it says, but generally speaking, the retainer agreements that I have had with clients through the various firms that I've worked at has generally said, hey, if we part ways and you continue with this case and we're on a contingency fee basis, so I'm supposed to get a percentage of whatever it is that you get from a settlement or from a judgment, from a verdict. If we part ways before that point, I'm entitled to reasonable costs out of whatever it is that you get. That's what you would, so you would still be, an interested party, so to speak, in that litigation, because you would be interested in getting paid out from whatever it is that they would eventually get on the back end. So, like if he's concerned about that, like, I'm to some extent sympathetic to the costs that are associated with representing someone, and every attorney wants to have those costs covered. But that's why you have that in that kind of a retainer agreement. But this whole this trying to convince her, by saying this is a federal court lawsuit, it's almost like he's trying to intimidate her with the process here by saying, you are a plaintiff in a federal court lawsuit. If you fire me, you'll have to hire another lawyer to replace me or represent yourself pro se in the lawsuit. And I mean, that technically is true, but the way that he says it is almost like, this is not that simple. This is not like that. Like, I don't believe you. I don't, it sounds gaslighting. I know that gaslighting is a term that is probably overused in a lot of ways because people, anytime there's a new powerful term that starts to sort of like come up in our collective consciousness, we probably start to overuse it. So I hesitate to say it, but it feels like he's trying to pressure her and he's trying to intimidate her by saying, like number one, this is a federal lawsuit. This is super scary. And that the process of you have to hire another lawyer or you have to represent yourself. This is like super, super scary. And then on the other hand, he's saying, oh, and by the way, like almost like he wants to dangle this little carrot for her about like, oh, by the way, they emailed me today because the director to do a documentary movie about you. Like I've been doing this other thing, and like maybe all this stuff that I'm helping you with will all go away if you get rid of me. It feels like it feels like a bad boyfriend, like a really bad boyfriend. But you are right in the middle of a lawsuit, so firing me is a little more complicated than sending a text message. I said this when I first read it. Not for her. I mean, kind of, because it's like she has certain concerns that she would have, but like, that's for her to figure out. If she, like, if she's firing him, he has to do what is required of him to let the court know, let opposing counsel know, and then beyond that, go with God, right? Like, this is your case, and you have certain things that you have to worry about. That's no longer my problem because I've done what I need to do. But like, he's trying to say like, no, this is more complicated than just firing me. You can't get rid of me that easily. Ugh. And then he says, I'm concerned about you. Ugh. I don't believe that. I don't believe that for a second. When I look at this, I don't like it. I don't like it at all. I don't like it for 2 seconds. Do you have replacement counsel? I need to be able to represent to the judge who is going to be taking over your lawsuit. Basically saying like, do you have another lawyer? Do you have someone else to replace me? Because you can't do it yourself. Oh man, we've got more sex bots in the chat. Let me, I forgot to make the subscriber only. Let's fix that. Okay. Sorry guys. So like, do you, you definitely can't handle this. You definitely can't handle this on your own as pro se in this case. So, we'll just who is it? Who's the other guy? Who's the new boyfriend? Essentially. I need to be able to represent to the judge who is going to be taking over your lawsuit. That's not necessarily true. The attorney that is withdrawing can represent to the court saying, I am no longer representing this client. I do not know who, if anyone, is going to represent this client afterwards, but I'm doing what is necessary of me to comply with the professional rules of conduct. I don't like this. This is a misrepresentation to his client. He's lying to her about this. He's kind of lying to her about this. And it's trying to intimidate her to stay in this attorney-client relationship that she doesn't want to be in. It's kind of gross, to be honest. And then she says, now you know it's me, because she had sent a video. And he says, no, I don't. No audio came through on that video message. If someone has hacked your phone, they would have access to your videos too. We need to speak on the phone live. And then she sends another one. Okay. Now, and here, okay, so here's, and we're kind of, I don't have a particularly organized way of going. I could have gone through this more methodically, but I'm just kind of scrolling through this. But here's the email from Howard King from Tuesday, August 30th, to J. Ellwanger, saying, I just got a phone call from Ashley Smithline, who blurted out to me that you were fired as her lawyer in April and have not been truthful about the reasons you failed to produce her for deposition. I told her that I could not speak with her and that I would immediately let you know of the call, which I am doing. Please let me know if I have your consent to speak directly to Ms. Smithline. You do not have my consent. Thank you for alerting me, is the response from J. Ellwanger, which he also, mind you, doesn't say, no, she never fired me. No, that's not true that she fired me in April. Or, yeah, she fired me for a minute in April and then came back to me and asked if I would still represent her. So gross. I'm so disgusted by this situation right here. Okay. And here's where stuff starts to get even juicier about the actual deposition and the psychiatry hospital. And like, I did not anticipate at all that we would be able to see communications like this. Like, this is such a huge like bomb that has been dropped. That is just crazy. Here's another, this looks like also from Instagram. A conversation between Ashley Morgan Smithline and another individual. I think it's someone different because now the some of the text, the Instagram text kind of like describing things is in German. So that's what tells me it's probably a different person saying, okay, so this person says, he claims you couldn't do the deposition because you flew to the states for an emergency mental health evaluation. And then Ashley responds, what? I had a shoot for a hotel. He's a lying liar. And then she sends a screenshot of text messages between two individuals. We'll get into it. And then the other person responds, I know it's obvious you didn't even fly to the States. He claims he can't show proof because of client privilege. He's saying he can't show proof. But the reality is he can show proof. He doesn't want to show proof because it's damaging to his case, not even his client's case. I can't even call her his client because he hasn't been her client since April 2022. That's bananas. It's completely bananas to me. Like, why would you lie about your client? Why would you lie about your client being in a psychiatric hospital on a completely different continent at that, when you know that those are all things that can be proved or disproved? Like, if she's in London and you say she's in Los Angeles, and it turns out she's on a photo shoot. She's on a photo shoot. There are other individuals that can come forward and say, yes, she was with me in London on this date. Or the photos themselves could be published somewhere, and then whoever publishes them describes them saying, yeah, we had this really great photo shoot with her on August 17th, 2022 in London. And she was great, by the way, mentally perfectly healthy. Like, it's just, it's completely it's bananas to me. The more I talk about this, the more worked up I get. And this is just crazy. Okay. And here's the text messages on August 22nd, Monday, August 22nd, 2022. This is like a week or so ago, between her and it looks like Jay Ellwanger. This looks like probably Facebook Messenger. It looks a little bit slightly different. So she says on August 22nd, mind you, August 17th, 2022 is the date of the date of the deposition that was supposed to happen on August 17th. August 22nd, she says, I'm leaving back to London on Wednesday. I'll do whatever I need to do. Please do not contact any of my friends. And the Carl thing was really out of line. He's a complete something. I don't know. There's probably a word missing, but who wants to be famous by being involved in this? So he's contacting her friends. I'm curious about what he's doing, contacting her friends. This is very strange to me, especially if he's not even representing her at this point. And then he says, does that mean you are going to get me a letter from your psychiatrist? And she says, no, I've been in London since March, not under the care of a therapist, psychiatrist, GP, anything. I don't know what you were doing contacting my friends, causing me greater trouble. Now I really want to know what he was doing, reaching out to her friends. And my psychiatrist, as most psychiatrists, prescribes me the meds I've been on for over 10 years, full stop. We don't discuss you. And then he says, again, you had a deposition in a federal case scheduled for a date to something or other. Ugh. Oh my gosh. I want to, And then she then has screenshotted that conversation and says, stop lying. Stop. I wasn't in LA for an emergency health session. Stop lying. I want to see what the rest of this text message says, though, where he says, again, you had a deposition in a federal case scheduled for a date. Like, it's like he's calling it it is a federal case. Yes, it is. But like, it seems like he's trying to call it, he keeps calling it a federal case. Like, like when people are when someone's really upset and getting into an argument with someone, and then like the other person responds like, don't make a federal case out of this. It's like, don't make this bigger than it needs to be. Bigger. It's like, I feel like he's using federal as to describe her case to try to intimidate her in the same sort of fashion. This is just crazy. This is nuts. Was she or wasn't she in London? Was she or wasn't she in Los Angeles on August 17th, 2022? That is something that can be verified very, very easily. You can also show flights. If she's on a flight to Los Angeles for emergency treatment in a psychiatric hospital, there are many ways to get receipts for that. So why would someone who understands this whole process lie about something like that? This is the big question that I can't wrap my mind around. And maybe I'll be able to like touch on it in conversation with other folks. But I think this is it here for me. And this is, yeah, these are the communications emails where Howard King responds to her saying, I know you told me that you were no longer represented by counsel, but as long as Jay Ellwanger is your counsel of record, I'm not permitted to communicate with you absent his consent, that kind of stuff. So all of that is in emails. It's in text messages. This is just absolutely insane to me. It's just, I still can't fathom the he's from my alma mater, dang it. We went to the same school, not at the same time, but like it's not a dumb school, right? Like you've got to be at a certain academic level in order to get into the University of Texas School of Law. It's a good school. There were many intelligent people that I went to school with. And I was very proud to go there. This guy casts a little bit of a shadow. I mean, at the very least, the morality issue, sure, okay, whatever. You can have immoral people that are also very intelligent. It happens all the time. But like, it just seems stupid. It just seems profoundly stupid to be lying about the things that he's lying about here. Because, like I said, they're easily verifiable. All right, let's get some questions and some super chats here. Meg Perry, thanks so much for the $5 super chat. It says, in the exhibit somewhere, she mentions getting Ellwanger a connection for a documentary about all this. Yes. Yeah, we went through that. So I'm curious about, about that. That's very interesting to me because of the fact that it would suggest that there could have been a particular motive here to, thank you. Hey, Holmesy. So there could be a potential motive for filing litigation to get, to get attention on you, help your career, that kind of thing. So that's very interesting to me. It calls into question the motivations for filing a lawsuit like this. Jessica Thomas says, thanks so much for the super chat. Says, is it possible that he remained her lawyer until certain fees were paid as part of their retainer agreement? As in, you cannot leave until pay. No, no. Regardless of whether a client pays you or doesn't pay you, if they fire you, you can't use that. You can't use that to basically hold them ransom. If they fire you, they fire you. You were required to do what you were required to do ethically, regardless of that can sometimes put a law firm into a little bit of a bind, financially speaking, because if there are certain hearings on the calendar that the client needs someone to represent them at, like they might be required to go to the hearing, they might be required to respond to a motion or something, like there are ways that can cost the firm some pretty money without the guarantee of being paid by this person. Ethical duties are ethical duties, regardless of that. Lawn Lumber, thanks so much for the super chat. Says, Senior Jailwanger has Alita scratching her head. Me, I've opted for a few choice cursey words. So many thoughts. Rob, we're going to talk about this. We're going to talk about this in about 15 minutes. Because I feel like in the course of the last hour and 45 minutes, I started from like, oh my God, this is crazy, crazy, crazy. And I've like just ramped up from there. Because I can't fathom it. I cannot fathom it. This is just crazy. Hayden wants to know, says, does this mean something for Esme Bianco? I'm reading into this. She might want a new lawyer too, but doesn't mean anything else bad for her case. So if I'm Esme Bianco, I also might want to be looking to talk to other attorneys at this point. I might, want to do that. And before I answer the rest, Secret Squirrel, can you put the link again to Eric Hunley's live stream that's going to start in 15 minutes? Because I'll pin it in the chat. I should have done that earlier. I'll pin it in the chat. That way folks that want to see us talk about this like brain explosion can join us. So yeah, I know Secret McSquirrel put it in the chat earlier, but I want to be able to pin it without having to scroll through. There it is, right there at Laid Back News. Boom, pinned. Okay. All right. But what does this mean for Esme Bianco's case? So, yeah, I did see some questions that folks have asked about, does this mean something for the merits of the case? Is the court gonna toss the case out? No. If anything, the judge is going to look a little bit more protectively at the clients that have been represented by this attorney, because of the fact that this attorney is doing some things that are very egregious and provably, demonstrably so. The court is not going to take that as an indication that the merits of their case are bad, because they may be looking at this as a situation where the client has been taken advantage of by the attorney, and courts want to be protective of that. They don't, I've talked about this before. Courts don't want a case to be decided through procedure. They want a case to be decided on the merits, or for it to settle, through negotiation process between the parties. But that's still like them working through the substance and the merits of the case, and then figuring out at which point they want to walk away. Right. But they don't like rote procedure to be the reason why a case goes away or gets decided in this. So this, if I'm Esme Bianco, I do want to maybe think about getting a new attorney. And she actually might not have that much of a choice, because there's enough here that he might need to withdraw. He might even have some issues with his licensing after this. I don't know. I'm not sure. Let's see here. Got a few more here. Oops. Let me see. Okay. Got to get through a few more of these here. Okay. SB in Tennessee says, wouldn't AMS have retained new counsel if she fired this guy? Not necessarily. Sometimes a client can be so pissed off with their attorney that they say, you know what, I'm going to figure it out later. I'll deal with hiring a new lawyer later on down the line. I just know I don't want you representing me because I'm so sick of you. So it doesn't, they can represent themselves for a period of time. It happens. Renee Viniski, welcome to Legalbytes. Welcome to Bite Club is what I meant to say. I'm very happy to have you here as a YouTube member. Welcome. Adiba Zaman, thank you so much for the super chat. Jay McCarthy says, Nancy had a great point about her location and stuff. I'm wondering if Ashley is actually lying. She said she was flying back to London on 8/22, but also said she'd been in London since March, hadn't she? Or didn't she? So it could be that she was, if you are living in the general London area, you can be saying, I've been living in London for a while, but maybe you just got back to specifically London because you were on location somewhere around there. Like for example, in LA, like if I'm, if I'm living in the LA area, I might generally say I've been living in LA for a long time, but I just came back from a project out in Palm Springs or something, because I was there for a modeling shoot, like that's something that I can understand that. But the thing is, it's verifiable. So either way. Okay. We've got more questions here. Marty Herford says, would you show and summarize the motion to withdraw went on with Eric that was not covered last night, and I think it will help illustrate just how the attorney viewed things. Yeah, if we have, there's going to be more than just me and Rob on there, so I think Viva's going to be there, Nate's going to be there, and I think Nick Requeta will also be on there from what I saw Eric saying. So yeah, if they have the patience for it, I can totally go through that on that live stream with them to sort of give some of that clarity. iStar Nimdrogel says, what if he was pressured by his other client to do this for the good of the collective against Manson? Has he a duty to do so? No, because you have, here's the thing about, I didn't even have a chance to really get into multi-party representation. So if one attorney is going to represent multiple clients in a single case or in related cases where they might potentially have adverse interest at some point, you need to have a waiver signed by both clients ahead of time. So basically saying at some point, I don't anticipate there being any issues in the representation here, right? Like I don't anticipate a conflict coming up, but if there is for some reason, because there's something that I don't know at this point, it could happen that a conflict comes up. I would need to step away from the representation here, because an attorney has all kinds of duties to every single client, current, past, and not future, but current and past clients. So if you have, for example, duty of confidentiality, any communications that you have with a client that are in the course and scope of that litigation or that representation, because if it's transactional, if they are giving you information or asking you for counsel on things, all of those conversations are confidential because they have to do with your representation of them as a lawyer. And like I said before, the reason for that is to promote more dialogue between the two so that the attorney doesn't have to worry about having to give up information that is, bad for their client because they're just trying to do their job. So, there's also a duty of zealous advocacy to every single client. And that's why when there's any kind of a conflict of interest that comes up and you have multiple clients, you've got a duty of zealous advocacy to one, a duty of zealous advocacy to the other. If you have information, you kind of have to step away from representing both of them. If you have information that has been given to you through those privileged communications, and then you decide, well, okay, I'm not going to represent this person anymore because, the things that they have told me are detrimental to their case and I can't really work with that. You also then, like, if that has a possibility of being in the interests of the other client, in other words, if acting on that information one way or another would benefit the other one and to the detriment of the one that you just let go of, that is also not okay, because that is using privileged information against that client. You still have to hold on to the confidentiality of those communications until your dying day. So it probably has to step out of representing both of them. So this pressuring, hypothetical pressuring of the attorney to like sacrifice one client for the others. Nope. Rules against that. MSC LRHD says, if he continues to represent Miss Bianco, isn't there a liability in that Manson's lawyer can argue he deliberately prevented Miss Smithline's depot as it would harm Miss Bianco's case? Yeah, there's like what I just explained there. That you can't use information that you got from one to use it against the other. Anyway, that's the last question that I'm going to answer here. If you guys want to hear more about this topic, hop on over to, there's a linked in the or pinned in the chat is the link to the live stream that's going to pop off in about 5 minutes over on Eric Hunley's channel. Join me and Rob from Lawn Lumber and Eric Hunley, and also Nate the lawyer, Viva Fry, Nick Ricada, whoever all is going to be there. It's probably going to be chaos. That's usually what happens. But I really want to keep talking about this because this is crazy. This is absolutely nuts. Okay. All right, guys. On that note, I'm going to end it. Thanks so much for joining me. And thank you to the mods. Secret McSquirrel. Are you the only mod that was on this one today? I really appreciate it. You are wonderful. And I know you've been dealing with all kinds of health issues. And I just want to say that I appreciate you very, very much. And thanks to everybody, all folks in the chat, folks that are engaging, folks that are watching without engaging. Be sure to like the video if you enjoyed this, if you found it interesting, if you found it informative. And if you haven't done so already, subscribe to the channel so you can get definitely more on this topic, because I might need to come out with more videos on this. This is just absolutely wild. Okay. I'll see you guys in the next